Hello everyone, bonjour tout le monde. Nous sommes très heureux d'être ici today with Professor Danielle Robinson, who is a world-renowned expert on the topic of access and benefit sharing. Professor Robinson comes to us from the University of New South Wales, where he works on issues of biopiracy, the governance of Indigenous traditional knowledge, access and benefit sharing in respect of biological resources and genetic resources, and combines that with work on international governance, including trade governance at the multinational or multilateral, regional and national levels. So he comes to us with a lot of expertise on this topic, and he'll be speaking to us today about a subject that's of interest to a number of researchers at the Centre for Law, Technology and Society, and researchers associated with a project called ABS Canada, Access and Benefit Sharing Project Canada, directed by my colleague, Professor Aguamanom. I think what we're going to hear today are a series of stories and case studies about successes and maybe some failures and challenges in the area of access and benefit sharing. This complements a lecture that we had earlier in the year by Professor Aguamanom about efforts to get a new treaty at the international level on access and benefit sharing. And Professor Robinson is going to speak about how those issues relate to on-the-ground case studies on access and benefit sharing, and efforts to update the Nagoya Protocol and the Convention of Biological Diversity on these issues. So thank you very much for ABS Canada and its funders, SSHRC and other funders, and the Centre for Law, Technology and Society here at the University of Ottawa for hosting the talk. I think you've all come to hear Professor Robinson rather than me, so I'll turn the floor over to him. He'll speak for a few minutes, and then we're going to have lunch come in. We'll take a pause, grab lunch, and then restart the presentation. Please join me in welcoming Professor Robinson.
Thanks everyone for being here, and thanks so much for inviting me to have this talk, and thank you a lot for your time here. I will talk to you about access and benefit sharing. I'm currently the coordinator of an access and benefit sharing capacity development project in the Pacific region. And so over several years I've been doing a bunch of case studies. They started mostly in the Pacific as part of that work, but then I got additional funding to do a few more global case studies. So I published a book on this in 2015, so most of this is sort of a summary of some of those case studies in the book. I thought I'd also, if I have time, talk a bit about some of the patent landscaping work I've been doing as well. So I've got a couple of recent papers that look at patent trends basically relating to genetic resources and traditional knowledge. So we'll see how much time we have. So I want to start by talking a bit about the Convention on Biodiversity and Nagoya Protocol, but I'm not going to spend too long talking about the specific language and law. We can certainly talk about that in question time. I sort of want to get into the case studies in more detail, and then go into some of the patent landscaping stuff later in the talk. And we'll see how much time we've got. Okay, well that was easy. So to start with, I don't know how much people know about this. So in terms of the basic sort of this issue, it really starts, well, my starting point for this is the Convention on Biodiversity in the early 90s. So the CBD, or Convention on Biological Diversity, has three sort of main objectives: the conservation of biological diversity, its sustainable use, and the fair and equitable sharing of benefits arising from the utilization of genetic resources. And that's something that gets abbreviated to ABS, to access and benefit sharing. And it's really about bioprospecting or biodiscovery. So the term utilization basically means research and development on genetic resources. And that, over the years, that's broadened to include traditional knowledge, and I'll talk about that in a minute. So in the early 1990s, many of you maybe have heard this from Professor Chidi's lecture. it was considered by many to be a potential win-win or win-win-win for science and innovation, as well as conservation and communities. And the idea with ABS was that it could potentially contribute to funding of conservation and sustainable use of biodiversity. Now, in practice, unfortunately, this has rarely happened. But as I'll sort of talk about today, there are some positive case studies. There are some circumstances where there has been a reasonable amount of benefit sharing, and you know, we need to think in different ways about benefit sharing as well. One of the things with the Convention on Biodiversity is that it does get, there's certainly plenty of critiques about the CBD. It's a broad framework convention. How many people are familiar with the CBD in this room? There's quite a few. So the Convention on Biodiversity sort of has a complex mixture of rights and responsibilities. So it talks about sovereign rights over biological resources. And so for Indigenous people, sometimes that's a bone of contention. Sometimes that's problematic or concerning because it prioritises government control over biological resources. The CBD does talk about intellectual property rights. There is sort of recognition within the convention itself that there will be research and development on genetic resources. And I think concurrently to the negotiations that led to the CBD, there were negotiations towards the TRIPS agreement. So there was an awareness that there were those negotiations going on in the Uruguay round towards the establishment of the WTO, actually. Also within that sort of, the idea of ABS is it's like a compensation regime. So if we're utilising for research, for bioprospecting or biodiscovery, the genetic resources, we should be sharing some sort of benefits, and that should be fair and equitable. And obviously that's often really challenging. What is fair and equitable? And we can sort of talk about some of the cases here. And then traditional knowledge has come into it, which makes the whole thing very complex. But it's increasingly, you know, it's very much part of the focus of the Nagoya Protocol, which has come subsequent to the CBD. Throughout, I've got a lot of pictures, so I do want to highlight the sort of reality of this. So I'm actually not a lawyer. I've done some legal studies. But for me, it's really important to make sure people understand the reality and the materialities of the plants and animals and genetic resources that we're talking about. So, you know, this is a stomach ache medicine in Australia called Buscopan. I don't know if they have it here, but it's based on a traditional. It's based on a traditional a plant that's been used traditionally by Indigenous Australians. Should I pause while they're doing that? Is it affecting the audio?
Yeah.
Yeah. That's okay.
It's okay. It's okay.
It's okay? I don't mind. I can keep going.
Whenever you're hungry, we'll stop for lunch.
Okay. Now, I guess one of the things that also led to the CBD was that there was quite a bit of talk about biopiracy in the early 90s and late 80s, and NGOs like it was called RAFI, but it's the ETC group now, and activists like Vandana Shiva were really prominent around that time in sort of highlighting sort of the patenting of certain uses of plant species or you know, microbes or animal species too, for a whole range of different uses. And so this is sort of a list from many of those NGOs, really, and you're probably familiar with some of these. So Hoodie is a really famous one, which originally was started off sort of like a bit of a biopiracy case, but then once some awareness was raised about the use of Hoodia, it was a benefit sharing agreement was subsequently established. So it's kind of like a retrospective ABS case. So the San people used to use Hoodia as a appetite suppressant in southern Africa, and CSIR in South Africa got a patent on certain uses of the Hoodia plant for appetite suppressant qualities. In the long run, that case hasn't, because of the benefit sharing agreement, there have been some benefits for the Khoisan people, but there's still a lot of issues with that particular case. People might have heard of the turmeric cases and neem tree, etc. I started my work on this in Thailand with the Human Rights Commission of Thailand, looking at jasmine rice and some of the issues associated with that. So the Human Rights Commission of Thailand and some of the NGOs were concerned that there was biopiracy associated with jasmine rice. There was a trademark on jasmati, which is sort of a merger of the words jasmine and basmati. There were patents on basmati, but there were also researchers looking at jasmine rice, and there were methods patents on using on specific milling and cooking processes that would make rice, a different type of rice actually, more like jasmine rice in terms of its texture and its taste, etc. So there was concern the method patent and the trademark were combining to be basically a biopiracy case in Thailand. So there's heaps of these cases, and there are literally hundreds and thousands of these sorts of patents. But it depends on your definition of biopiracy, or what we should include as biopiracy, or what is not biopiracy, and it varies depending upon your perspective of this whole issue. Certainly, a lot of Indigenous people. I don't want to speak too broadly about Indigenous concerns, but there have been often statements about the patenting of life forms as sort of being problematic for many different Indigenous groups globally. If you there's no real global sort of legal definition of biopiracy, and this is maybe part of the problem, but certainly the Convention on Biodiversity and the Nagoya Protocol sort of have language that's very relevant to this issue. This is a typology of the different sort of potential types of biopiracy. That it's from my first book, but it's sort of adapted from a definition by Dutfield, Graham Dutfield. So you can have certainly patent-based biopiracy, and that's the most prevalent one. And this is sort of a typology there. I'll just let you read it. But you can also have non-patent biopiracy potentially. So you can have plant variety protection or plant breeders' rights on biological resources or traditional knowledge that may not have been authorised by a country or by Indigenous communities, and that can be equally as problematic. Certainly, plant breeders' rights have a similar monopoly to a patent, so it can be 20 years. Deceptive trademarks can have similar effects, but not exactly the same. And so there's been some cases where deceptive trademarks, like the Jasmati case that I just mentioned, have been talked about in that same sort of biopiracy frame. Or misappropriations, and that's a common word and that's used sort of interchangeably with biopiracy. I've sort of differentiated it here, but some people use it in the same sense as biopiracy. Certainly in forums like the WIPO Intergovernmental Committee on IP and Genetic Resources, Traditional Knowledge and Folklore, the term misappropriation is used as a sort of more polite term than biopiracy in the negotiations there. Or some countries actually only refer to erroneous patents in those forums. So there is sort of continuous debate about whether biopiracy even exists. So the Nagoya Protocol, was brought in 2010 and came into force in 2014. And this was, after decades of work relating to ABS and recognising that there were real problems with the definition, that it was still quite ambiguous and there needed to be more more legal text to assist countries with setting up some sort of framework in their national jurisdiction to implement access and benefit sharing. So the Nagoya Protocol, focuses on the fair and equitable sharing of benefits arising out of utilisation of genetic resources. Utilisation, again, still means research and development. So it's not about biotrade, so we can still trade in biological commodities. If we're not doing research and development, this ABS regime doesn't apply, and that's something that does cause some confusion. There are different regimes around the world, so different countries implement it in different ways. So most countries only really focus on research and development on genetic resources. But the scope of the Nagoya Protocol is a little bit broader in terms of what's included in that definition for access and benefit sharing, and the definition of genetic resources. So the definition of genetic resources has been broadened to include biochemical derivatives or biochemical extracts, and that's something that's been really important because there were a lot of arguments, particularly say from the cosmetic industry, that ABS didn't apply to them, that they were doing research and development, but not on genes and DNA and RNA. They were doing research on just using extracts from the genetic resource. So there was an ambiguity there, and it was particularly cosmetic industries, but also sort of parapharmaceutical and sort of health food type industries that were trying to avoid that ABS regime, or were claiming that the scope didn't cover their activities. So that's included now. Customary law and community protocols, there are mentions of those, so it encourages countries to recognise customary law and community protocols in relation to traditional knowledge and genetic resources. Traditional knowledge has been included in the definition, so there is specific text on accessing traditional knowledge with the prior informed consent of communities. And that's really important because it was ambiguous in the original CBD text. And it was included in the Bond guidelines, but they was just guidelines. So this was an important additional development for the Nagoya Protocol. Then there's also user measures and compliance measures, monitoring and checkpoints, and a clearinghouse mechanism. So all these other aspects help us monitor who's using the genetic resources, traditional knowledge, and then we can check these things potentially in the clearinghouse mechanism. If you've had a look at the clearinghouse mechanism on access and benefit sharing, it's currently a lot of gaps, like it's a work in progress. So you can see the start of a framework there where you would be able to potentially, if you find a patent, for example, and you're concerned, where did the researchers get this genetic resource? Did they get permission? You can then go in and check the clearinghouse mechanism to see if they got a permit from the country you suspect they got the genetic resource from. It's probably not at all a perfect system, but we can certainly talk about that in question time. But it's sort of it's a start on improving what we had under the Convention on Biodiversity. So I'm going to talk about a few case studies, and the first one is this Simtek case. So it's from the Cook Islands, which is this beautiful place near Tahiti in the middle of the Pacific, and there's a researcher who is currently based in Sydney now. His name's Dr. Graham Matheson, and he grew up in the Cook Islands and is now a dual citizen of Australia and Cook Islands. And playing rugby, he'd witnessed the application of a traditional medicine to fractures, to bone fractures. So people would break their arm. Rugby's a pretty rough game. So people would get injuries, and traditional healers would use a wrap, a sort of a medicine around the fracture, as well as sort of imbibing a traditional medicine, and these bones would heal very fast. So he had done medical training at my university, actually. I'd never met him until sort of we were both in the newspaper one day, and he decided to do the research on this traditional medicine. He thought this was a great sort of opportunity, and he'd become a sort of an orthopedic surgeon, so he was looking at bone fractures and joints, etc. so I think he was doing his PhD, and he approached the House of Ariki, the House of Kotonui. So there's two legally recognised Indigenous groups, Indigenous representative houses in Cook Islands. The Kotonui are the sub-district chiefs of the Cook Islands, basically. And they're charged with cultural affairs, traditionally, cultural heritage, maintaining culture. And so he approached the Kotonui, which has a sort of a general assembly. They meet a few times a year to talk about whether he could do research on this traditional medicine. And as a Cook Island Maori man, he knew that he couldn't do this research without getting approval, getting prior informed consent. And he kind of admitted when he first started this research, he knew very little about the Convention on Biodiversity, but he knew it was the right thing to do, to speak to the Kotonui about this. So he met with them, and there was no ABS law at the time in the Cook Islands, but he met with them, and they subsequently agreed to let him do the research because they could see the benefits for humankind, for science and technology, and that if this could be turned into a more usable medicine rather than like a traditional medicine, it might benefit potentially thousands of people rather than just, you know, a few dozen or a few hundred. It's a very small place, the Cook Islands. So they allowed him. They allowed him to do the research, and subsequently he has. It's found to be really useful. It's now. He's set up a company and it's been patented. And some of the interesting things about this particular case, he made an agreement with the Kotonui whereby they are one of the shareholders in his company. So he made them part of the company, and they're actually recognised as co-inventors on the patents. So this is kind of an ABS case where there's no ABS framework, and actually a lot of the examples are kind of like that. There wasn't an ABS law there, but he did follow a very similar sort of procedure. Now, the research has been relatively successful, so the drug for bone healing has been licensed to a veterinary company, so they're testing it on horses and dogs and cats, etc. And that's a smart way of doing R&D for a potential pharmaceutical, because it can take decades to get through clinical trials to be able to use the pharmaceutical on humans. So licensing it to a veterinary company makes some sense. He's also set up a cosmetic product line, but using a similar medicine, using some of the same ingredients, and that provides benefits into further research and benefits that could potentially go to Kotonui. At the moment, the Kotonui has said that the benefits can go back towards the research. So the money, the benefits in terms of money are being put back into research at the moment. So ultimately, the idea is that there will be dividend or royalty payments to the Kotonui. The Kotonui are they're also, aside from being charged with cultural affairs, they're also involved in traditional conservation practices, customary law, customary practices, including one called Raui, and that's marine protected areas. So they protect their coastlines. They have no-go zones and no fishing zones for certain parts of the year, or permanent Raui zones. And so in terms of the CBD idea of access and benefit sharing, this is quite a good example, because the benefits should be going towards an organisation, an Indigenous organisation that will help conserve biodiversity. It also does a few other things in terms of thinking about monetary and non-monetary benefits. In a lot of these cases, there's often not a lot of money involved, and this is one of the real challenges and one of the issues that keeps coming up in ABS is that there's often not a lot of monetary sharing. In this case, there's obviously there's not a huge amount, but there has been other things like technology transfer and local jobs. So there's a local facility there that processes natural oils, and there are other sort of little local benefits in this particular case. There's employment and things like that. But I think in that case, a lot of the benefits are still sort of to come, and that's pretty normal from sort of a pharmaceutical type research project. So the benefits usually take a long time. The next one I want to talk about is a slightly different case. It's interesting because it's not a research and development example, so it's just research for sort of pure scientific research purposes. So this was the French Museum of Natural History, IRD, which is the French Research Institute for Research and Development, and Pro Natura did a big sort of expedition of Espiritu Santo, which is this big island it's one of the biggest islands in Vanuatu, so another Pacific case study. And they received permission from the Ministry of Lands and provincial government, and so they got a permit to come in, which is part of the, under the convention and Nagoya Protocol. Prior informed consent often means a permit, first and foremost, is getting a permission to come into the country and do the research, and then also often another prior informed consent with local communities. So in this particular case, chiefs in local villages also had to give prior informed consent. So they sort of had a council meeting, agreed to let the researchers into their community under certain conditions. So one of the conditions in this case was that traditional knowledge shouldn't be collected. Initially, the researchers did want to do that. There was a part of the project that was interested, but they said no in this particular case. Just to be, a bit conservative about what the researchers might do with it. And there was sort of there were a number of agreements in the contract. I've seen this particular contract. There was an agreement to provide duplicates to the government departments involved. But ultimately what happened in this case, so these are some of the sites in Espiritu Santo, really beautiful place. They did the expedition in 2006, and the agreement actually only lasts for 2 years. So this is one key thing that we're talking to Pacific Island countries about at the moment in the capacity building that we do, is that the agreements, ABS agreements, subject to mutually agreed terms, so that's part of the convention and Nagoya Protocol. The contract has to be a good contract, basically. So they have to have a longer duration than a couple of years. So in this particular case, it's a 2-year contract. It lapsed after that. And it has to be enforceable in some ways. So we do bring in a lawyer that sort of helps these countries with the language in the contract and some of the clauses that are needed to make sure that there is potential arbitration and remedies and ways of resolving non-compliance with these sorts of contracts. So what happened in this particular case was, it's a fairly positive case still. So they did this expedition, they identified a bunch of new species that weren't previously known to science. They may have been known to local people though. They produced this great book called The Natural History of Espiritu Santo, and they shared something like 400 copies of the book with the government, with local libraries, with all these different schools. So they did sort of share educational benefits, and they were a purely scientific expedition. They were mainly taxonomous, and they looked at terrestrial as well as marine species. They produced all these posters for schools. They restored some boats and sheds for the Maritime College to help with the expedition. So they did a lot of positive stuff in this particular case. But there's always, with most of these, there are issues. There's no sort of perfect access and benefit sharing cases that I've come across to date. They didn't share the duplicates back, and that was part of the agreement. So there's been a lot of to and fro about this between the researchers and the government. I think some of the duplicates have come back, but I think the researchers were saying that there isn't sufficient storage in Vanuatu. It's very hot, high humidity, so they need to be in certain cabinets with air conditioning, etc. So this has been an ongoing issue. The Department of Forest would like samples back. There were limitations in terms of the payments to local guides and local communities, so they were paid like pretty pathetic amounts of pay, even sort of standard payments in Vanuatu. There were concerns that traditional knowledge was being collected. People were just being curious that traditional knowledge could have been passed to the researchers. And some of the scientific publications were initially shared, and the book was shared, but then there's been a whole heap since. So sometimes the identifications or the publications have taken, 5-6 years or even longer. So we've been basically, our project has been repatriating some of these scientific journals to the government. So the VKS is the Vanuatu Cultural Centre and the Department of Environment, because the researchers haven't shared that basic information. And there's a bit of colonialism, I think, inherent in that. They've identified these new species, but they're not sharing them with the country that they got the species from. Of course, the Department of Forest and Environment would love to know about the new species that have been identified in their country. So there's pros and cons to that particular case. This is another one. The Moroccan Argonne case is quite a well-known case now. It's again another ABS type arrangement outside of an ABS framework. So there's no legal framework in Morocco yet. There's a draft regulation or a draft policy underway now. So at the time, this was set up by Professor Zubida Sharuf, who's at University of Rabat. And she is a researcher that's been looking at the uses of argan oil for a long time. So argan is used in hair care and skincare creams. It's very popular now. A lot of you would have seen it in the supermarket. And there's a number of different brands that are used. This particular supply chain that we looked at here was sort of a Cognis and L'Oreal supply chain. So Cognis was like the intermediary company. They've been bought out by BASF. So BASF, huge German chemical company. They were selling it to L'Oreal, world's biggest cosmetic company. L'Oreal obtained a number of patents. Professor Sharuf, the Moroccan professor, was on a number of those patents, so she was heavily involved. And she made sure that L'Oreal and Cognis set this up with benefit sharing. So she was very determined to make sure that there were benefits for Morocco, and particularly for Berber women or Amazigh people in Morocco. And so she helped set up 5 cooperatives initially, and there's more than 5 now. And they're women only, men get involved. But traditionally, for 1,000 years, Moroccan argan oil has been used for a number of these purposes, for food and cosmetic purposes, hair care as well. And it's women's business, and that's traditional. So Berber women have been doing this for something like, and it's documented, it's at least 1,000 years. So it was really important that Berber women were beneficiaries in this particular case. Initially, when they got patents, and in the early stages of the research, they didn't have to get a permit, but what they said they did tell the authorities, and they got an export permit. So that's something different. ABS permits are actually supposed to be something quite different, but the companies involved said at least the authorities were aware we were doing this. And this was, I think, in the early 2000s, so when I think there was still a lot of unknowns about how to do ABS properly. I think this was sort of a test case actually for L'Oreal to try and do ABS well. This was one of their first sort of cases, and I think they have a few others now. This was profiled mainly by Cognis, though. Cognis were doing a lot of the behind-the-scenes work because they were the intermediary company that were buying the oil and making it cosmetic grade, basically. L'Oreal also bought out the Body Shop, so significant quantities of what they were producing was going into Body Shop products. And so a lot of the stuff you buy from Body Shop is from this supply chain we're talking about here. The patented products, though, were high-end, very expensive cosmetic creams that L'Oreal was selling. So the benefit sharing was actually the high-end stuff, related to the high-end stuff. And I think by volume they were selling significantly less of that than they were of the stuff that just contains the oil. So the innovation that L'Oreal did to get the patents was actually flavonoids and proteins that were derived from different parts of the plant. They weren't necessarily derived from the oil. They wouldn't have been inventive if they were derived from the oil, because that was what the Berber knowledge was on. It was on the uses of the oil. This is the Argonne Reserve. It's a biosphere reserve under UNESCO. It's an extremely important ecosystem in southern Morocco. The trees are often 100 years old or more, these sort of mature trees, and it's very culturally significant as well. There is customary law around the uses of the tree, and so people are allowed to, they have usufruct rights, so they're allowed to use trees even in these protected areas, but only during certain seasons. This is the process, so they pick the fruit, they collect it as families, it's often a family activity. They dry it, and then the women take over. This is us going into a cooperative, so this is part of a cooperative, and the women, I don't show their faces because they're quite conservative. The women crush the nuts to extract a kernel. I think I've got a picture of it here. The dried fruit, it goes to the nut. The nut is about the size of an olive, or they look quite like olives. They break it, and the almond is what they press to get the oil. And then this pressed cake is like the byproduct. So it's interesting what L'Oreal did. They examined the byproduct, which usually just gets put into candles and soap. And the byproduct is actually where they get a flavonoid, or a protein, if my memory's not so good about that. But I think it's a flavonoid. And that's what they've patented for use in the high-end cosmetic cream. Traditionally, this was worth almost nothing, and it was fed to goats or, like I said, put in soaps or candles. It's very waxy, whereas the oil was the valuable thing, and still is very valuable. So the way the benefit sharing agreement there works is that the pressed cake, this stuff, these tubes that you can see here, is bought for a huge premium, so 40 times market prices. So this is a benefit sharing agreement, and they have a contract. I've never seen the contract though. It's confidential. So this is a benefit sharing agreement that is kind of like a fair trade model. And this is something we're seeing more and more with cosmetic companies, is that they'll pay a premium, in this case a huge premium, for a product. So they're buying by volume and adding on the extra benefits by volume. And that's something that pharmaceutical companies won't do, obviously, because they're more likely to do 20 years of research and then share a percentage, a royalty. So this is a sort of a new way of thinking about doing benefit sharing. And it goes into a benefit sharing fund, a social fund. The companies don't talk about this explicitly as a benefit ABS agreement. They talk about it as a social fund, corporate social responsibility thing, and I think they do that deliberately to avoid any issues with the Moroccan government, but it very clearly is very similar to an ABS agreement. There is fair trade payment for all the oils and everything as well. So there are heaps of benefits in this particular case, and a lot of it's monetary. So they buy equipment, they buy this machinery which saves a lot of time. They build laboratories, so the women are actually involved in doing lab testing of the oils. So it's marketed by sort of Body Shop, I think Body Shop, but it's marketed by some of the people involved as a sort of women's empowerment project. A lot of these women never worked before. They never did official work. They did farm work and looked after children before. So for the first time ever, they've got their own money, which is a big deal in a country like Morocco. And a lot of the benefits from the social fund have gone into playgrounds and creches. So you can see here, the women can bring young children to the creche and work, and then have money, and the children are looked after, etc. The women all sort of talked about the really good solidarity they had there. They've gotten funding from the EU and a number of donors to build cooperatives because of the success of these things. So they've got some really nice looking cooperatives as well. They've done literacy programs. And I interviewed a whole bunch of the women, and most of the interviews show that they're really, there's been a whole heap of positive benefits. So in terms of monetary benefits in this case, you're talking sort of in the hundreds of thousands of euros. We're not talking millions yet, but it's the supply chain's quite big, so the oil would be in the millions, but that's not what the benefit sharing is on. So it's a really interesting one. There's been a lot happen. There's a lot of community benefits in those communities and those cooperatives. I'm running a bit out of time, so I'll talk a bit about this Madagascar project, but this is a huge project as well, quite like the Moroccan one, so it's a real summary. So in Madagascar, there's this ICBG, so the US government I think they're phasing it out now, but through the National Institute of Health, they had this International Cooperative Biodiversity Group project, and it involves, it gets funding from the NIH, but also from partners. So Dow AgroSciences and ISI Pharmaceuticals were also contributing funding to this particular project, and because the US government hasn't ratified CBD, but they've signed it, and I think that's part of the reason why the government funding has to be seen to be complying with the Convention on Biodiversity. And so in this particular case, they have an agreement, and they have local meetings with communities, get prior informed consent, and there's a lot of benefit sharing in this. With the laboratories, so there's been benefit sharing with the research labs in Madagascar, but then there's also a lot of benefit sharing with the communities involved, where they do the sampling, where they actually do bioprospecting for soil, mainly. They take soil for microbes, and they're doing bioprospecting for in marine areas for marine microorganisms and algae and sponges, etc. They're avoiding traditional knowledge, and I think they're deliberately sampling microorganisms in extreme environments for drugs, for particularly cancer and heart disease related drugs, but they're deliberately avoiding traditional knowledge to avoid problems, basically, in this particular project. Now, they have provisions for royalty sharing with the government if the drugs are achieved, and I think the royalty rates are quite good in this case. There might be something like 20%. I've never seen the agreement in this place, but they gave me a lot of the information. The US researchers and the government gave me a lot of the information. So with the local communities where they bioprospected, they would have meetings with the communities beforehand, get prior informed consent, and then they would ask the communities what benefits they wanted, what should we share, you know. And so they had upfront benefits before they'd done any research. They would pay for things, and they would do it through local NGOs like Conservation International, based there, and they would do it through the Missouri Botanic Gardens, which kind of acts like an NGO in Madagascar. So they built schools. So in a lot of areas they were building schools because you can get really positive benefits in a very short amount of time from building schools. They built ecotourism walkways, so there are some benefits for conservation, which is sort of what the CBD initially aims at. But you know, the communities were often asking for other things. They bought boats, and you can see there is a little Conservation International sticker on the front of this. So fishing boats for local communities where fishing was important. So this is in the north of Madagascar. Wells for communities that had shortages of water, markets and other things were some of the upfront benefits. So this is one of the few cases where we've seen sort of maybe close to $1 million spent in upfront benefits for local communities and for the government. And in this case, so this started more than 15 years ago now, so this was probably 20 years ago now. There have been no drugs discovered by this project, at least that's what the researchers say. Despite all that research, all this activity, and it's quite common that researchers haven't identified anything. But when you interview local people, they're sort of concerned about that. You know, how can they be doing this for 20 years and not discover something? So that does sort of raise, local people were raising question marks, or local government were even raising question marks. They did share some technology transfer, so there are a bunch of non-monetary benefits as well in this case. So machines for testing for malaria. There were conservation reserves. There was money put into conservation reserves. So there were, this is one where there's endangered lemurs in this, and there's a threatened species of tree. And you can see this is a big fire break on the hill to protect that area. So there were conservation activities out of the benefit sharing. I mean, this was the question that people were asking. The researchers code the genetic resources or the biochemical extracts from the genetic resources with passport data, send it to their laboratories in the US, but who monitors the further use? The researchers say that they're very transparent. They share it with the government in Madagascar, but in the long term, the government's wondering what's going to happen. And one of the things that's come up with the contract is that the ICBG has done a lot of these activities around the world. This is just one example. And they have these two-stage contracts typically. So they say we're doing initial biodiscovery to start with, and then we'll enter into a second stage of negotiation for benefit sharing when we get to the commercial stage. But there's concern that these agreements aren't really strong enough to protect the rights of the countries, the provider countries, because of this two-stage agreement. That how are they going to make them come back and negotiate those benefits at a later date? So there are benefits built in up front, but in the long term, there's concern about how this contract might work. And the same thing goes with another one in Papua New Guinea, which I'm just going to skip because I'm running out of time. But it's a very similar sort of agreement to the ICBG one from Madagascar. So there's a whole heap of conclusions, and this is just really a few little points from the case studies. And I'll very quickly run over some pattern landscaping stuff, but it's important to have partnerships, and there's a few examples where we did see that. So the Moroccan Argonne case seems like a very positive case where the cooperatives on the ground seem very happy with the sort of partnership that's been set up, and trying to get that sort of partnership arrangement that endures, that is long term, and has a supply chain even, provides employment and income, would be really useful from some of these agreements. It won't work for all agreements. That works in that case because it's a cosmetic supply chain. There's all sorts of different types of benefit sharing, and I've talked about monetary and non-monetary in a whole bunch of these, and they can take different novel approaches, like a fair trade type approach. I don't think there's anything wrong with that. Prior informed consent is really important, obviously getting PIC, getting permits, and then also local prior informed consent from local communities, especially where there's traditional knowledge involved, but also just access to genetic resources. And often ABS regimes are being framed around access to land, basically. So in Australia, if you look at our ABS system, a lot of the way that it operates is to do with landholders. So landholders have to give prior informed consent for entry into their land. So in a lot of countries, this is the way the access part of ABS is working. It's not necessarily about utilisation, although utilisation is a big factor in this as well. So there's a number of different options in the way countries can write their legislation. And they can say access and utilisation, or access for the purpose of utilisation, etc. In some countries, there's a committee to deal with multiple genetic resource types. And so, for example, in Vanuatu, this is really important. They have a biodiversity advisory committee. So they advise the director or the minister, I can't remember which one, who is the determining authority, when a permit comes in. And so it goes to a committee that includes agriculture, fisheries, forestry, cultural centre, all the relevant, important government authorities to talk about that permit. So it's not just dealt with by Department of Environment, who is the focal point. So it's important that different departments communicate with each other, and a committee structure often helps, because in a lot of countries where I've been working, like in the Pacific, you see permits come into multiple departments, and multiple different types of permits come in, and often a department will just approve it without consulting other departments. So the model that we've seen in Vanuatu seems to be working quite well now. So that's something that's probably quite useful in a lot of countries. Now, having different types of permit processes, so having a simplified prior informed consent process for academic research can be a good idea. And Australia has, the federal government in Australia has this sort of approach. If you do basic ecological research on biodiversity, they want you to get an approval quickly, so you can get one in less than 30 days in Australia. And you sign a statutory declaration. So if you breach that, if you're found to be fraudulent in that statutory declaration, it's a criminal offence. So that's a very simple way in Australia that they deal with the prior informed consent process, or permission to enter, say, a national park to do research. And as I've mentioned, contracts need to be really well written. In some of these countries that we've been working, it's really hard. There's not a lot of legal capacity, and so that's some of the work that we've been doing is sort of making sure that there's third-party transfer rules and dispute settlement, that it's clear which jurisdiction disputes would be resolved, etc. So there's a lot to think about in terms of the contracts for mutually agreed terms. I want to leave time for questions, so I'm just going to really briefly mention that we're also doing patent landscaping work in Australia, as well as the Pacific and New Zealand. And this is part of a broader sort of set of activities we're doing to identify who's patenting what, basically. And we're using ethnobotanical texts to identify patents. So in Australia, for example, we've used ethnobotanical texts and found more than 1,300 patents that relate to plants that have indigenous uses. And there's a lot of sort of indigenous concern about a lot of those. Some of them are found across many countries. So the top one there is Indian mulberry or noni. It's found all throughout Asia Pacific, so it's transboundary. This is another issue with ABS. A lot of these species are transboundary. But some of them are endemic to Australia. So Nicotiana species, there's heaps of patents relating to Nicotiana species, and they're mainly tobacco companies that are interested. Now, these were used traditionally as a chewing tobacco by Indigenous Australians, so we're interested in looking at these to see if they're biopiracy cases, basically, or if they're spurious patents, or if they're problematic in various ways. The famous case that sort of has happened in Australia is to do with Kakadu plum, and there's been patent applications by Mary Kay Company. In Australia, we filed submissions and those were defeated. In Australia, you can do pre-grant and post-grant oppositions. Some countries you can't do that, but they do also have a patent that's been approved in the US. What happened was that on radio, a representative in Australia said that they were getting the materials from the Northern Territory. The Northern Territory has an ABS law. They said they had a permit on radio. We asked the government, there is no permit. So we then, we sent letters to Mary Kay around that time, and there was we've never had an explanation for this. Now the US patent actually says that they're getting the examples from a supplier in New South Wales. So we don't know what's going on here, but one of the problems with Australia's ABS laws are that we have a federal system and there are gaps. So the Northern Territory and Queensland have a law, the federal government has a law, but New South Wales, where the company says they're buying it now, there's no ABS law. So we've got this really gappy system, unfortunately. So this is sort of an ongoing sort of example that we're obviously concerned about. I'm going to skip that one. I might wrap it up there because I want to leave enough time for questions. I'm mindful we've got to get out of here pretty soon. So there's certainly lots more I could tell you about the ABS cases and about the patent landscaping. Thank you. Yes?
First I want to say thank you very much for the presentation. The access and benefit sharing, I like particularly the first case study, that represents some of the ideas that within our research here that we believe should be included in an access and benefit sharing system. But I did have a bit of trouble with, you kept talking about traditional knowledge, people avoiding traditional knowledge.
Yes.
It seems you believe that the traditional knowledge of the plant could be separated somehow from you could go get a plant from somewhere.
Yeah.
And then say, okay, you didn't tell us about this aspect of it. And therefore, we don't really have to pay money on this. Do you think that is equitable? Does that form a fair way of doing access and benefit sharing, especially considering the lack of knowledge on the part of indigenous communities?
No, I think it's really problematic, and I think it's often researchers avoiding biopiracy. They don't want to be called biopirates, and they're doing whatever they can to avoid that that sort of label. So I think, for example, the ICBG team that did the Madagascar research had previously done some activities in Suriname, and where they were looking at plants and traditional knowledge, and they admitted it and that it was part of their permit application, etc. And there were NGOs and local communities that were concerned about that and what they were doing with the traditional knowledge. There were issues with the local prior informed consent process. And so I suspect this is just my thinking about it, is that the researchers decided, well, in future we're going to look at soil microbes where we don't think there is any traditional knowledge to avoid controversy. In the Vanuatu case, it's different because actually the director of the Vanuatu Cultural Centre said to the researchers, we don't want you looking at traditional knowledge. So that was the government telling the researchers, this is none of your business. And that's because local chiefs had said, and local communities had said, traditional medicines and things are off limits. So a lot of the expedition focused, it did focus on plant species, but heaps of it was on like arthropods and animals and invertebrates. So they did kind of have a different focus in that. Not that there's not traditional knowledge on those things as well. But yeah, they were told specifically to not look at traditional medicines and things like that by the government. And I think that was again sort of concerned that they would use it as a lead to drugs, and it wouldn't be. It's difficult to prove the connection in a lot of these cases. So in the pattern landscaping we do, we use ethnobotanical texts, and then we find these patterns. A lot of the patterns don't say we're using traditional knowledge, but we suspect they are. But there's nothing in patent law that makes you disclose that. You don't have to, and that's why in some of the international forums they're asking for a patent disclosure of origin requirement. So in the WIPO Intergovernmental Committee, many countries are asking for patent disclosure of origin. So you know where, first of all, the genetic resources came from, and then you can try to make the connection if they've used traditional knowledge as well. But yeah, traditional knowledge obviously adds a level of complexity to ABS because it is connected to the plants, but it can be disconnected to the plants as well, of course. Yeah. Other questions? Yeah.
Can you argue against benefit sharing if the patent is legal?
Yeah, this is something that comes up as well about erroneous patents and what is biopiracy, and there's no, there isn't a legal definition. So if patents are valid, you can still be utilising genetic resources and traditional knowledge, and in those cases, if there's an ABS regime, you should be sharing benefits. Legally, you should be sharing benefits. So there are certainly valid patents granted over biochemical extracts and utilisations of particular species for certain things that will be valid, that should be sharing benefits. Yeah, there's lots of those. Yeah. But we sometimes also see spurious patents where maybe there shouldn't be a patent as well. So the Kakadu plum example in Australia, it was for a cosmetic cream, and we filed submissions arguing that it wasn't novel and that it wasn't inventive, because there were companies that had used it in cosmetics before. And so Kakadu plum is one of the world's highest sources of vitamin C. Another Australian company had been using it in cosmetics for years. It was hard to find proof of that. Indigenous people had used it. There was traditional knowledge. And so we had evidence of that. Their uses were more on as a food, like a high energy food. So they would take it. So you would argue that they knew that there was something in it, like the vitamin C in it was high, that they were getting energy from it. But I don't think Indigenous people were using it as a cosmetic. We've got no evidence of that. We can't really find any evidence of that. but certainly they were using the genetic resource. It's endemic to Australia. You can't get it anywhere else. So in that particular case, the patent was found to be invalid in Australia, but then the US version, it's a revised version, it's been granted. And I don't know, you can have a look at the patent yourself, see what you think.
Okay, so should it or should it not be the same product and same usage?
Can you explain what exactly you mean? So in that case, we were trying to use traditional knowledge as an argument about novelty. So we were trying to argue, we were trying to find traditional knowledge associated with potential skincare uses, basically, to say that this patent might not be valid, that it might not be novel. But we could only find commercial uses. And the commercial uses were probably the things that invalidated that patent in that case. So that was us doing a bit of activism, basically, to try and sort of knock out a patent that we didn't think was valid. There's plenty of other patents that do get granted that are seen as valid because they might be doing something new. You know, they might be doing something inventive that maybe is a bit different to the traditional knowledge, or maybe it's maybe it's a very different use. Maybe it's a much more high-tech version of what the traditional knowledge was doing. Those can certainly be granted. Yeah. I think with that particular one, it just looked like a mixture that was similar to what was already on the market. That's why it was invalidated. It was never granted, actually. It was an application that was never granted. Yeah?
So when these ABS agreements are being made, who exactly is at the table? And who is representing, I guess, communities and indigenous groups, and if there are tensions within the community about entering these agreements, how are those resolved?
Yeah, I mean, that's really difficult, and it's up to national governments to sort of define that in their legislation, and that's sort of the way the Nagoya Protocol operates, but that's often not perfect in many countries, certainly in colonial situations like Australia and New Zealand. Particularly, say, Australia, it's really problematic because Indigenous people, Aboriginal and Torres Strait Islanders in Australia, they don't have a lot of rights recognised in terms of the genetic resources. So the Nagoya Protocol talks about established rights over genetic resources. Australia's legislation is not very good. So we have something called native title, which provides land to Indigenous communities or Indigenous applicants that can prove connection to country, continuity over centuries. And that's often hard for people to prove because of horrible colonial history that we have in Australia. So it's often, it really depends on the country and the circumstances. So in Cook Islands, that particular case, the Kotunui are sort of a legally recognised Indigenous body. I mean, that case wasn't entirely without a little bit of controversy. It's fine. Like, people are generally pretty happy with it. But there's a House of Ariki. So the House of Ariki are the chiefs, the paramount chiefs that sit above the House of Kotunui. So in that case, we've had some of the paramount chiefs say, well, the agreement should be with us, not with the Kotunui. So it's often, in most cases we've seen there can be issues about this, and certainly even in Vanuatu as well, the sort of chiefly structures have been introduced. Like, there weren't really chiefs necessarily in the past. That's a colonial construct. So if you go to the chief, the customary system there sort of recognises a bunch of elders that usually meet. Sometimes researchers might go to the wrong person or might just go to one chief. We've certainly seen this sort of thing in Papua New Guinea as well. There's a really gendered aspect to it in Papua New Guinea. There's been a lot of concerns about the fact that women can be excluded and may not be able to speak in certain forums relating to these sorts of issues. So yeah, it can be really challenging, and often I think agreements may be made with the wrong people. And I think there's some examples from Latin America where that's happened. Brendan Tobin's done work in that space. Where there's been agreements made with sort of more amenable groups, whereas the traditional knowledge might be with this group. This group's just sort of maybe doesn't have the traditional knowledge, but they can give access to the resource. So that can be really challenging. Yeah. And there's no answer really to that. I don't know how you resolve that. Having good national systems would help. And having those national systems set up in very close consultation with Indigenous communities is important. And there's some of that happening in Queensland, for example, in Australia. Some of that's happened in South Africa, for example. And in the Pacific generally there's quite good consultation with communities because the governments are run by Indigenous people. You know, there's often good consultation, but it differs country by country. Yeah.
Yeah, it's a really good point, and I think it's a live issue in Canada too, given that we have national Indigenous organizations that claim to speak for Indigenous groups and many grassroots Indigenous communities who there's a lot of tension between those different levels, and who to speak to is a really complicated thing. Sort of related to that, I wondered if you could talk a little bit about inequities in bargaining power between the different parties at the table.
Yep.
Because I know that in the Canadian context in particular, a lot of Indigenous communities don't know about ABS and don't appreciate what sort of range of tools that they have to defend traditional knowledge. And I wonder if in Australia, for example, there's been any capacity building work, like has the government done anything to kind of level the playing field? Because it's a nice idea, but then when you have corporate lawyers from a pharmaceutical company and a small Indigenous community, there's obviously a bit of an imbalance there in terms of power.
Currently, Australia's doing very little. We have a Conservative government that's not really interested in environment, generally. Australia, in the past, Australia started setting up this system, and there are some sort of checks and balances. How effective they are, I'm not really sure. So in Northern Territory and I think the Commonwealth laws, they're both quite similar. The researcher is supposed to negotiate and get mutually agreed terms of a contract with the provider. The provider is often the landholder. It can be an Indigenous community if they've got native title or if they have land. They have private land, they have Aboriginal land. I think it's the Director General of the Department of Environment or the Chief Minister in the Northern Territory has to sign off. So they kind of, and there is sort of a clause in there saying that they have to have time to consult with legal advice, they have to have access to legal advice. So there's a number of little clauses in there that say that they have to have the Indigenous community or the land provider, could just be a private landholder, have sufficient opportunity to get advice, to know whether they're getting a good deal, and then there's a sign off by that Director General or Chief Minister, and hopefully that helps. I know in a couple of cases in the Northern Territory I think that's kind of worked. But the landholder was the government in that case, so they had plenty of lawyers and stuff. Yeah. In the Pacific, we're doing capacity building as the ABS initiative. This logo here, including with communities, and a lot of people don't know about ABS and the rights of communities, and depending upon the country, the community may not have a lot of rights or may not have a lot of access to information. And say Vanuatu, there's very limited capacity in terms of the staff. So I think for the country there are like 5 biodiversity officers in the central office and then maybe another 10 in provincial offices for the whole country. I think it's 83 islands. So that's really tough. That's really hard, yeah. Anything else? I think we might get kicked out in a minute. Okay, thank you everyone.